Buying a house can be very rewarding, but let's be honest, it also takes a lot. Most people just can't afford to do it cash, and so they opt for getting a loan from the bank and paying it off over a very long period of time. You need to be creditworthy to get that sort of credit, and ready in general to make that kind of commitment. What if you're not? What if you just don't qualify for that credit, or you haven't even found the best place to actually buy a house yet? Perhaps you're only living in a certain area to be close to work and wouldn't even want to buy a house in that area. You still need to live somewhere, right? Perhaps you need a space for your business and it just cannot afford to invest in a warehouse at the moment. Well, that's where renting comes in for most people. But renting a place to live or do business from can be both exciting and stressful, especially if you don't have a clear idea of what your rights are in that situation and how to enforce them if it's necessary to do so. Welcome to Legal Juice, the podcast. I'm Rorisang Salom. Let's talk about the lease agreement today. Always say, please remember, I may be an advocate, and yes, I may be your friend, but this is not an official legal consultation. Our discussion is only meant to break down a few legal concepts here and there in a quick chat. If you have a legal problem, please make your way to an attorney that you trust to discuss it more fully with them. Our chat is only meant to help make you more aware, but it might not be enough to map out a strategy to fix a problem that you actually have. But of course, I do hope it's enough to get you started. If this is your first time tuning in, thank you so much and welcome to Legal Juice, the podcast. Take some time to listen to some of our previous episodes just to catch up to where we are. Believe it or not, there are laws in our country which govern relationships between tenants and landlords. In today's episode, I'll sometimes call them the parties, just for clarity's sake. They're meant to regulate that relationship so that neither will be exploited. Before we get into that though, let's discuss what actually makes a lease agreement. In the event that you enter into an agreement with someone who owns a property to the effect that you will live on that property, or in the case of a business, you will operate from there and pay rent in return, then you've entered into a lease agreement. That agreement may be one where you pay rent on a weekly or a monthly basis and can include any type of immovable property. So you could, for instance, rent an apartment or a flat, a warehouse, a back room, or even a farm. The agreement doesn't even have to be in writing in order to exist. Anytime you have such an agreement, you've officially entered into a lease. Remember, a lease agreement will create both rights and obligations for a tenant, who is also sometimes called a lessee, and a landlord or landlady, who is also sometimes called a lessor. Whilst it doesn't have to be in writing, I strongly urge you to write your lease agreement down. Experience has taught me, and to be honest, part of the reason I have a job in litigation is because contracts which are not written are always much harder to prove than those that are actually written down. Anytime you enter into a contract with someone, any contract for that matter, unpleasant as it might be, I'd urge you to always think of the worst case scenario and try to provide for it in case it happens. What would happen if your tenant or landlord were to breach your agreement, say by refusing you access to the property one day or failing to pay rent 1 month? If you wanted to enforce the agreement, it would be a lot easier to prove not only that it exists, but also its terms if it were in writing rather than not. So the question then becomes, should you write down your own lease agreement? I think it's always a wise idea to seek the advice of experts when you're not sure about something and when it doesn't fall within your area of expertise. But let's say you don't have a managing agent. In fact, let's say you're pretty much a regular person like me, with the regular house and a granny flat at the back which you might want to make a little extra money from. You might consult with an attorney then to draft a lease agreement for you. and if they're a good attorney, they should manage just fine. But it will certainly cost you some money to do that. One option is to agree with the tenant that they will carry that cost, and perhaps call it an admin or legal fee of some sort. You should probably include that in your written lease agreement. If you aren't able to do this or don't like the idea, there are many stationery and bookstores which carry and supply ready-made lease agreements which are relatively inexpensive and easy to find. I'm not going to mention them here today because, well, they haven't paid me to do that, but more importantly, I don't really want to vouch for them today, so use them at your own discretion for now. I just want to make you aware that they do exist and are available. Other legal service providers, such as those who provide insurance for legal matters, also sometimes provide free and easy to access and easy to use lease agreement precedents, which you basically fill in like a form. A basic internet search will help you find one, but I would caution you to use your own discretion when relying on these ready-made documents. Always remember, a lease agreement is a contract at the end of the day. It must be personal and speak directly to your agreement with your landlord or tenant. Try to avoid a one-size-fits-all approach by having a proper discussion with your tenant or landlord about what it is that you actually want to get out of the lease agreement. In my opinion, I think you could absolutely consider drafting your own lease agreement. And if you have no idea where to start, consider these questions. Firstly, which property are you actually renting out? Specify it in as much detail as you can. If it's a granny flat, does it include the use of the garage or not? Does it include parking in a parking bay, for example? What about the use of the back garden? Be clear and use as much detail as you possibly can. Secondly, how much rent will be charged and how often will it be payable? Most people pay their rent monthly, but you may, for instance, agree that rent will be payable less frequently, maybe once a quarter. It's entirely up to you, but you should consider the circumstances of both the tenant and the landlord when you decide this. Include all the other charges which the tenant may have to consider, such as whether they'll pay for their own electricity, water use, garden maintenance, security, key replacements, that sort of thing. It's also a good idea to make provision for maintenance in the lease agreement. Who will pay when something is damaged on the property? What's become very popular is the phenomenon of landlords taking a deposit from the tenant when they move in. They keep this in an interest-bearing account and use it to pay for any repairs which are necessitated by the tenant destroying anything. Should the tenant decide to vacate the property, the deposit is then returned to them. It's really an excellent way to secure the landlord's interests in the maintenance of the property and almost gives an unspoken undertaking that the tenant will be careful in handling the property as long as they occupy it, since they don't actually want to lose their deposit. Another thing to consider is how long you want the lease to run for. Many residential lease agreements are renewable on a yearly basis, and it's probably a good idea to do this. If the relationship between the tenant and landlord is new, they may not yet know if they want to be bound to each other for very long. Starting with a year-long commitment allows you to dip your toes in the pool of the relationship before deciding whether you want the arrangement to be more long-term. But of course, this is entirely up to you. You may also want to provide a notice period for terminating the lease agreement. Supposing you were renting an apartment and suddenly wanted to leave. That could prejudice the landlady if she hadn't found a replacement for you yet. Who would pay rent in the meantime? Negotiating a notice period is almost inevitable, but perhaps avoid entering a lease where you'd have to give notice of your intention to vacate, say 6 months in advance. That's a lot. A reasonable period of notice in my books is between 1 and 3 months. Some lease agreements will provide for penalties if the tenant wanted to give a shorter notice period before vacating. You can negotiate this. If you are a landlord, don't forget to specify if the rented property is for a family or a single person and put that into the lease as well. some properties by their nature are just not meant to accommodate a whole family at a time, and it can cause an inconvenience and expense to you and other tenants, if you have them, to have too many people in certain spaces. Alright, now let's talk about the landlord's obligations. A landlord must give you access to the property so that you can actually use it and enjoy it, and give you everything you need to access that property. Like, for instance, keys and a remote to the gate, or a tag if that applies. He must also ensure that the property is in good condition so that you can actually use it. So he can't avoid maintaining the property so that it's decent enough to use. You should always take the chance to report any defects to your landlord, and especially do so when you first move in, so that the landlord does not rely on your deposit to pay for repairs to damage which existed before you even moved in. It's most important that the landlord gives you your privacy. You're entitled to that as a tenant. A tenant is entitled to the undisturbed possession of the property as long as the lease continues, and certainly as long as you haven't breached the contract, say by not paying the rent. So for example, your landlord can't rent out a back room to you and suddenly just want to start using the same space you're renting for his own storage purposes. Likewise, he can't, for instance, impose his relatives from out of the province upon you by expecting you to accommodate them in your back room while they visit, on the basis that he owns the room. If you are a tenant, you remain entitled to use the property with no disturbance. It may of course be necessary to disturb your possession under certain circumstances. Like, for example, whilst repairs are being done to the ceiling or floors, but this should be communicated with you ahead of time and should not mean that you are kicked out of the space which you rent. Sometimes tenants rent out a property which doesn't per se belong to the landlord. The landlord has a duty to warrant against the tenant's eviction by some other person. Let's make an example. Supposing Jabu, who's from Matatiele originally, decides to rent out a back room somewhere in Katlehong from a lady he met. Let's call her Rennie. In that scenario, Rennie is the landlady, Jabu becomes the tenant. What Rennie doesn't tell him is that the room actually belongs to her mother, who happens to live in Limpopo. So as far as Jabu is concerned and knows, the room belongs to Rennie. In this instance, Rennie has an obligation to warrant against Jabu's eviction by a third person, such as her mother, who has a better title than she does, since he had no idea that the property belonged to the mother. If of course he knew this all along, then the relationship should have been between Rennie's mother and Jabu himself. Finally, every landlord is obliged to pay the municipal rates and taxes that are levied against his property. If he fails to do this, it may lead to the disconnection of services such as electricity connection. A paying tenant is entitled to these services, and since the municipal account is in the name of the owner of the property, the landlord must ensure that it remains up to date so that services are actually provided. It is possible, of course, to agree that the tenant will purchase his own electricity, pay for his own water use, and so forth, if the parties agree to this. Now that the landlord's obligations are clear, we can move on to the duties of the tenant. A tenant's first and probably most important duty is to pay the rent. When the agreement is entered into, the parties should agree on how much rent must be paid, when it must be paid, how it must be paid, and where it must be paid. Can it be paid using cash, EFT, or even set off against some other payments? It should be clearly stated in their agreement so that there's no confusion about this. Anytime a tenant fails to pay his or her rent, we will then say that he or she has breached the agreement. The second obligation the tenant has is to actually take care of the property he lives in or occupies with his business. He must make sure that the property is used for the exact purpose it was intended and agreed. So for example, if the leased property is meant for residential occupation, the tenant shouldn't really start using it to run his car fixing business if he happens to be a mechanic, or run a salon from there if the property is not suitable for this. I recommend that you have a discussion upfront with your landlord if you have these sorts of intentions, so that you can properly determine what the property will be suitable for. You will of course at some point vacate the property when the lease ends, unless the lease is renewed. When this happens, your obligation as a tenant is to return the property in decent condition, and more specifically, in the same good condition you found it in. Now there will of course be reasonable wear and tear, but it shouldn't go beyond that. So for example, if you and your landlord drove on the landlord's driveway every day for a year, there will be a need to effect some maintenance to that driveway. This, in my opinion, would amount to reasonable wear and tear, since it cannot be avoided. But if, for example, you break a window on the property, you can, as a tenant, be expected to pay to have the window repaired, since you could have avoided that damage. Do remember, however, that as a tenant, you can't be expected to pay for damages to the property if they were not your fault, or if they were caused by some other person. Now, in a perfect world, every landlord or landlady would get along with their tenant and we would all live happily ever after. But I'm afraid it just doesn't happen that way. Sometimes parties breach their lease agreements. Sometimes a landlord or tenant dies or becomes insolvent and it becomes necessary to end the agreement. Let's say either the tenant or landlord breaches the agreement by not performing their duties in terms of the lease. For instance, maybe Jabu from our previous example doesn't pay his rent, or Rennie doesn't give Jabu keys to the property even though he has paid his rent 6 months in advance. Step 1 would be to notify the other person that they have breached the agreement. It's best to do this in writing. A letter works well. Give them a period of time to fix the problem, and if they fail, you can then cancel the lease agreement. If you have lost money, you can sue the other person for that money. We call that seeking damages. If the amount you have lost is less than 20,000 Rand, you can go to the small claims court in the magistrate's court to do this without having to pay a lawyer, by doing it all on your own. If you are the landlady in the scenario, you can then also evict the tenant once you've cancelled the lease agreement. Another option which is available to you is to approach what's called the Rental Housing Tribunal in your province. This is an independent body. Think of it as a sort of court, really, which solves disputes of this nature between tenants and landlords. They offer a free service, so if you feel taken advantage of by either your landlord or tenant, please approach the tribunal for assistance. I'll leave their details in the description below for you. Back in the day, lease agreements were mostly seen as the reserve of people who had fancy, high-value property to rent out and money to spend on them. Today, however, we know that lease agreement templates can be found on the internet and in certain stores, so they're more widely available. I really encourage you to explore your options here to safeguard your interests as both a tenant and landlord, whether you're renting out a back room in the township or apartment in the CBD. Take the opportunity to step up from doing things the old way next time you rent a space by formalizing your lease and putting it in writing. Good luck to all of you. Please remember to comment down below and share your experiences and stories with renting out a property on our Twitter page as well, @juice_legal, that's our handle. Thank you so much to our sponsors, the Makers Valley Partnership, and to Kopana, our producer, but most of all, thanks to all of you for listening. Until next time, ya rate later.